everybody interested in the topic of mergers and acquisitions, but we have our different reasons for being here. As lawyers and advisors in mergers and acquisitions transaction, if you ask them the metrics for knowing when a process or a transaction is a success, their answer is definitely going to be different from that of an investor. Am I right? Yes. As a lawyer or an advisor, your interest is to see the parties put pen to paper, closure to the deal. You collect your money and you walk away. The investor, then it is at that moment that his own challenge begins. Because for him, putting pen to paper is just a means to an end. Correct? From the perspective of an investor, how do you know that a transaction is a success? Let me have somebody tell me the answer. From the perspective of an investor, how will you tell that a mergers and acquisition transaction has been a success?
Does anyone want to answer that? Anyone?
Yes, let's make it an interactive section because that is what it's supposed to be. Okay, you know as an advisor that your own interest is to, hold the hand of your client until he puts a pen on paper. And once he does that, you get paid. But the investor, why does the investor or the business owner want to go into mergers and acquisition in the first place? Yesterday, the answers were provided. Increased efficiency, increased profitability. The bottom line is he wants more money from his business. And in doing this, to arrive at that point, that is where the issue about the human factor comes in. The topic we were given is employment and executive compensation issues in mergers and acquisition. I prefer to look at it from the perspective of employment issues in mergers and acquisitions. Because even the executive is an employee. And the executive compensation is just one of the employment issues that arise in the course of mergers and acquisition. We've been told a lot about the need for corporate governance. We've been told enough about how prepared a particular business is for acquisition, by keeping the books properly and then making his business more profitable, more compliant, and all that will attract an investor to look at it. All this has to be done by the employees. You look at the senior management. Yesterday when our friend, I think Peter, was talking, he underscored the need that when you start talking about having your business merged with another entity, that you should carry the senior management along. It's not for nothing that he pointed it out. Because if that business is going to be profitable, it depends on the team that is going to make it profitable. And in every talk about mergers and acquisitions, somehow for the business owner, it's an opportunity and he is excited. I'm talking about both the seller and the buyer. But the employees, more often than not, are not as excited. You know why? Because it comes with a lot of uncertainties. Some people are going to be let go. Usually that is the case. So it's not unusual when talks about mergers and acquisitions start in a company, you see the people inside that company working, looking for other opportunities, putting out CVs and all that. Why? Because they don't know how it's going to pan out. At that particular moment, the history of a particular employee in his organization, yes, it might aid the employee and make him look like a veritable prospect that would be retained, but nobody is sure, because at the end of the day, the decision is with the company that acquires the other company, or the stronger of the parties. Or however you look at it, the investor will at the end of the day say why he wants to retain this person. Yesterday still, I remember listening to one of the speakers. He mentioned about maybe if it's a financier or a financial acquisition, sponsored by a private equity firm, that usually they don't want to bog themselves down with management issues. So they might decide, look, this person or that person is taking too much salary, why don't we shed it down to the other person? And in such situations, you can see them letting off some people from the senior management level and then trying to get the other ones to step up and take roles with a view to increasing efficiency. Now, because of all this, invariably, the point I'm trying to make is, when mergers and acquisition take place, you acquire the business, you acquire the inanimate aspects of the business. But as far as you are talking of a human being, an employee, call him whatever you choose to call him, you cannot acquire him, so to say. However, if you put forward the right incentives, you can retain him. If you put forward the right incentives, you can make him want to work with you, because you cannot make him work under compulsion. Lawyers here would know it's the mantra before now in employment circles that you cannot force a willing employee upon an unwilling employer. It goes the other way around too. You cannot force an employer, a willing employer upon an unwilling employee. There are always options. So, in view of all this, as you are going into the mergers and acquisition, one of the things you consider along the line as you're doing the DD is you're looking at the talents that you have inside that, either the target company or the acquiring company, that you hope will drive the growth and make your dream of increased profit come true. You are looking at those that you are going to let go, and you are looking at those that you really want to retain. And then you are strategizing on how to make those you want to retain want to stay. At the same time as you're strategizing on how to minimize the cost, not just financial, but other costs of letting those people you want to let go. I don't know if you've seen a situation where you let go of a particular employee and somehow he's living like the politicians. He has followers that want to live with him. And then the scenario changes immediately because the team you were looking at are no longer there. So, these are some of the issues that arise. And like I said, it arises from the fact that you cannot compel the employee to work for an employer that he doesn't want to work for. So also, you can't compel the employer to keep an employee that he doesn't want. It has to be mutual. In fact, in Nigeria, we have this, in our Company and Allied Matters Act earlier mentioned, there is this provision that when mergers and acquisition happen, there is usually a court order sanctioning the mergers and acquisition. And in the process, there's an order made vesting liabilities and obligations of the other company on the mergent company. But there is a very important exclusion, and that is with regards to the employees. The employment contract, you don't vest it in that way. Specifically, our law says you have to discuss, in those circles is called the transferability of employment. It has to be with the consent of the particular employee, in fact the parties, so to say, before you can transfer existing employment in maybe the target company to an emergent entity. Okay. About the transferability, that is one of the problems. Then the other one, which I've mentioned in the passing, is about redundancies, because they are going to happen usually if you have the target company, and it could be that one of the problems with the target company, like we've seen in some clients, is that when they started with lean staffing, and everybody had something he's bringing to the table that is making the company perform. However, over the years, people ask for favors. Their children graduate from school, especially in Africa, and then because you know somebody there who knows somebody, and then they keep getting in. Not because they are the best for the various posts, but because they know people, and by the time the company gets bogged down, the operational efficiency is no longer there. However, it may be that the owner of the business or the manager of the time, he notices these things, but he lacks the political will to say, I'm going to let these people go or let the other people go. But when a new player comes on board via merger and acquisition, he has no such considerations. So invariably, even if he has to employ new hands, he has to let go of the dead wood that is clogging down the profitability of the company. And that is where redundancies come in, because each person has a contract by which he is there in the company. It does not matter whether he entered through the door or through the window. He has a contract. And it may be that it is in those sectors where collective bargaining agreements hold sway, so that his contract is even going to be more fortified by the provisions of that collective bargaining agreement, so that letting him go comes at some bigger cost. You know about what they call a severance pay. Like where you have employees who are members of a trade union, and then your company has a collective bargaining agreement with the trade union. Before now, given an example with Nigeria, the employer somehow had a way of, I wouldn't say persuading, but compelling the employees to stay out of unionization. However, a very important change happened in Nigerian law in 2011, when our National Assembly passed what we call the Third Alteration Act, which some of us consider that the National Industrial Court used to get some undue jurisdictions assigned to them way beyond what everybody was expecting, because we weren't looking at it. Sorry, let me digress a little. It started from the position of a Supreme Court judgment in 2007, where the Supreme Court held that notwithstanding the National Industrial Act provision that makes the National Industrial Court a superior court of record, that it was still an inferior court, because it is only the Constitution of the Federation that could give it that status. So the president of the court moved speedily, and somehow, before anybody knew what was happening, he pushed a bill through at the National Assembly, and the bill sailed through. And inside that bill, there was a provision that said the National Industrial Court could apply what they call international best practices in deciding matters before it. Before then, we had a section 12 in our Constitution that required that any convention, international convention, that is brought into Nigeria will have to be localized, sort of, by an act, a specific act of the National Assembly, passed specifically mentioning that convention and domesticating it. Until then, we could not apply the provisions of the convention. However, after the passage of that Third Alteration Act, the NIC has gone ahead to hold that with the provision made there that it can apply international best practices, it's now looking at ILO conventions as a representative of international best practices. And without the necessity of having it domesticated by the National Assembly, those provisions, they look at it as binding or persuasive in their decision of matters before the court. What it means is that everything about, ILO, International Labour Organization, how they are pro-labor in everything they do. So everything regarding unionization, and one of the last decisions that I read in one Aloysius and Diamond Bank said that you can no longer just dismiss an employee. Lawyers here know that before now, in the private sector, they say the employer can dismiss his employee for good or bad reason. Yes, you don't even have to give any reason at all. And that the best the employee can get is to get paid an amount equal to his salary for the notice period, assuming he was dismissed without notice. But with the third alteration in place in Nigeria, it is no longer the case. And then they made that decision and said, you can no longer dismiss for good or bad reason. You have to give reason. And that the reason has to relate to the ability of the employee to perform. Or some other things like you are structuring your business and you find the services of the employee redundant. Things like that. So when these things happen, there are going to be redundancies. And what the unions have continued to do in order to kind of assure themselves of security of employment is to make payouts prohibitive at the end, where you sack an employee without regard or for any reason not connected with his performance, or what they call for any other good reason, like you are restructuring. So they are like, well, it's not our fault, you're restructuring, fine. They are going to go. However, there's this thing they call golden parachute, which they continue to include in the clauses that they are negotiating on behalf of their members. So that when they are going with sufficient money, sometimes enough to enable the person to start something small time if he wants to. Okay, now redundancies, there's the issue of transferability of non-disclosure and non-compete agreements. You know, when you employ particularly people in top management levels, they come in, and because they are the people you rely on to drive your business, everything about the business has to be disclosed to them. They know too much about your customers, your processes, everything. So usually you have a clause in their contract where you prescribe them, maybe at the end of their employment with you, that for so long a fine, they are not going to maybe within a particular radius of where you are operating, operate a business that is in competition with your own business. Yes, these things are of interest to the people who are coming to pick up your business, because, give an instance, if you are somebody who is into bakery and you're making bread, you started the bakery and you were the manager for so long a time, and then you say you want to sell, and somebody comes along, and after the discussion, you allow the person to buy, only for you to move further down the street to reopen another business in competition. That would defeat the purpose of the person purchasing that business entity. So also, the same way it is with top management employees. When they are leaving, the employers usually at the point of their employment would have included what we call restrictive covenants inside their contract of employment. And the restrictive covenant, though the courts have held that restrictive covenants are presumed to be unlawful and unenforceable unless the employer shows that what is provided there is necessary for the protection of his legitimate business interest. And they decide on that by looking at the kind of secrets that is made known to that person, given the position in which he was employed. And that informs whether they say that it is reasonable or unreasonable. When they decide that it is reasonable, then it can be enforced against that particular employee. And they also look at the time frame, because some get too ambitious. And then you say that a man, if he leaves your employment, is not going to engage in that kind of business or engage with that particular client or some of the clients that he has been managing before he left within a space of, some say 6 months, some say 3 months, others get ambitious and say 3 years. And when you do it that way, the longer the time, the duration you stipulate, the more likely the court will find it unreasonable. But the shorter the time, the more likely the court may find it reasonable on the ground that that time would have given you enough time to enable the person who replaces the living employee to get across to those clients in order to hold your business interest ahead. Now the question is, since there is what we call privity of contract, if I enter into a contract with you, then a third party can neither take a burden or take a benefit out of that contract that he wasn't a party to. So if there is merger and acquisition and a new entity arises, remember, there is no transfer, employment is not transferable as a matter of course. And then a new entity arises, and that senior management person has to leave, whether by choice or because he was forced to. What happens to his restrictive covenant agreement? Is he free to still maybe move down the line on the street and kick up a competing business, which will invariably be vying for the market space with the new entity that comes on board? Of course, for the investor, it won't be a funny situation. So they also want to know, what do we do in order to ensure that such things don't happen? There is the issue of employment benefits. They've talked about it when our brother talked about taxes. In Nigeria, we operate the payee system of income tax for employees. I don't know the way it is in Uganda. But if you operate the payee system, and there are a lot of other things, like other payroll-based contributions, statutory contributions, that has to be made based on the employees and their earnings in the company. And if, for lack of proper corporate governance, the target entity hasn't been compliant, then the acquiring entity might take up an unusually big burden, unexpected burden for him. Like apart from the payee in Nigeria, we operate what we call contributory pension scheme. We no longer do the defined benefit scheme for pensions. So what we do is that even in private sectors, it applies now that once you have up to, I think, 10 employees, then you are obligated at the end of each month to deduct 7.5% of what is supposed to be the employee's salary and remit it to his chosen pension fund administrator for continuous investment and management until he is of retirement age. And then the employer is supposed to contribute also 7.5% to match what the employee contributed. Now you can imagine what the amount will come to over some years if the employer has not been compliant. In Nigeria, the law provides that the pension fund administrator is the person to ask the employer for it if the employer defaults in the payment or making that remittance or contribution. Of course, as an employee, the PFAs or pension fund administrators will say, we send text to you that your employer hasn't brought forward your contribution or made remittances. But as an employee, you find it difficult to walk up to your employer and say, why have you not made the contributions? And if you do, he has explanations, and you can't really compel him to, unless you want to take the next door out. However, the PFA is also looking for clients, so they are not eager to do that. So at the end of the day, unless a situation arises where they have no escape route, that is when it's computed. So in a situation like this, if those matters are not looked into and perhaps factored into the negotiation for the deal, or because if you really want to do the deal, it can happen, thanks to lawyers and other advisors. Like, I've seen a lot of explanations on how you can make it happen, even where it's like a high-risk deal. You simply have to make allowances for it, escrow and all those other things in order to make the deal happen. If you're minded to make it happen, it will happen. However, the important thing is that you avert your mind to it, like the judges will say, so that you don't make a decision without the proper being fully informed. You're fully informed and you make allowances for those things. And even in letting your employees go, like I mentioned, severance pay. In letting your employees go, the people that you want to let go, apart from the influence that they may have on the others that are left, if the way and manner you engage with them until you arrive at the people you are letting go is not transparent, it might tell negatively on the morale of the employees that are remaining, because they are like, okay, so we are the sacrificial rams because you just saw money and you don't care about us. So how am I sure I won't be next when next time comes? So they are there, and then they are looking out for some other place that they think are more employee friendly. Apart from that, you're also worried about how much you have to pay out in severance benefits. So if it is properly managed, you might have a situation where it is staggered. I've seen some entities like in the Access Bank, Diamond Bank merger that was mentioned earlier. Usually they first give the employees the option of bowing out by yourself. They give you an incentive. They say if you want to resign by yourself, you will get so much. So some actually take their leave at that moment. Then others have their own structure, the payment, like when PHCN unbundled in Nigeria, what used to be our public electricity authorities. At some point they unbundled, and there were a lot of negotiations over the years, and the employees who were paid out following the acquisition by private investors, some got immediate payment, some staggered payment. If you get staggered payment, you get more. If you get immediate payment, your own is at a particular range. So those are some of the ways you can talk about managing them. Of course, I've mentioned the issue of unions. They are not to be neglected because they have even their nuisance value, even when they know that they might not be able to go to court and prove their case. I've had situations where we go to court and we get injunctions, and you serve them with your injunctions and they are doing what they are doing. It's not the best, but that is where we are in Africa. So they have their nuisance values. Sometimes you start engaging with them early enough. What I have seen in my work as an employment lawyer is that if you start early enough to engage with them, you stand a better chance of passing across your message. And even if the union leaders fail to understand it, their followership do understand it. I've been invited to a company at one time when they had that kind of situation, and I issued an opinion. After the opinion, they invited me to come and address the employees because they have received a notice from a trade union that they were coming to have a meeting with the employees and demanding a check of dues because our law says the junior employees automatically belong to unions. It is for the senior employees that they have to opt in before they become members of unions. But for the junior employees, once they're employed, they are members of